Amendment 13, Abolition of Slavery, passed by Congress January 31st, 1865, ratified December 6, 1865. The 13th Amendment changed a portion of Article 4, Section 2. Section 1. Neither slavery nor involuntary servitude, except that as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. Section 2. Congress shall have power to enforce this article by appropriate legislation. Common interpretation, the 13th Amendment by J.M.O. Green and Jennifer Mason McRoad. Slavery is Americans' original sin. Despite the bold commitment to equality in the Declaration of Independence, slavery was illegal in all of the 13 colonies in 1776. By the start of the Civil War, 4 million people, nearly all of African descent, were held as a slave in 15 southern border states. Slaves represent 1/8 of the U.S. population in 1860. Many think that slavery ended with the Emancipation Proclamation issued by President Abraham Lincoln on January 1st, 1863. However, the Emancipation Proclamation freed only slaves held in the 11 Confederate states that has seceded, and only in the portion of those states not already under Union control. The true abolition of slavery was achieved when the 13th Amendment was ratified on December 6, 1865. The first section of the amendment declared neither slavery nor involuntary servitude except as a punishment for crime whereof the party shall have been duly convicted shall exist within the United States or any place subject to their jurisdiction. The amendment is unique in the Constitution because it bars every person from holding slaves or engaging in other forms of involuntary servitude, whereas most constitutional provisions only constrain or regulate the government. It's unique in another way as well, although the Constitution obliquely acknowledges and accommodates slavery in its original text. The 13th Amendment was the first explicit mention of slavery in the Constitution. The most immediate impact of the 13th Amendment was to end chattel slavery. It was practiced in the southern United States. However, the amendment also bars involuntary servitude, which covers a broader range of labor arrangements where a person is forced to work by the use or threatened use of physical or legal coercion. For example, the 13th Amendment bans peonage, which occurs when a person is compelled to work to pay off a debt. Originally a Spanish practice, peonage was practiced in New Mexico territory and spread across the southern United States after the Civil War. Former slaves and other poor citizens became indebted to merchants and plantation owners for living and working expenses. Unable to repay their debts, they became trapped in a cycle of work without pay. The Supreme Court held this practice unconstitutional in 1911. Barley versus Alabama, 1911. Most scholars also assume it would violate the 13th Amendment to order specific performance of a service contract. Example, this situation would be where an employee has a contract to work for a full year but wants to leave after 6 months, forcing the employee to continue to work instead of paying a financial penalty to get out her contract. would almost certainly violate the 13th Amendment. Notably, the amendment doesn't allow a person convicted for a crime to be forced to work. Thus, prison labor practices from chain gangs to prison laundries do not run afoul of the 13th Amendment. The 13th Amendment has also been interpreted to permit the government to require certain form of public service, presumably intending to military service and jury duty. In addition to the first section's ban on slavery and involuntary servitude, the second section of the 13th Amendment gave Congress the power to enforce that ban by passing appropriate legislation. This provision allowed Congress to pass laws pertaining to practice that violates the amendment. For example, the Anti-Peonage Act of 1867 prohibits peonage. In another federal law, 18 U.S.C. Clause 1592, makes a crime to take somebody's passport or other official documents for the purpose of holding her as a slave. Section 2 of the 13th Amendment has a broader applicability as well. The Supreme Court has held that this provision also allowed Congress to pass laws to eradicate the bandages and incidents of slavery. The Supreme Court has never defined the full scope of what the bandages or incidents of slavery are, and instead has left it to Congress to flesh it out a definition. In the civil rights cases 1883, the court held that the racial discrimination in private inns, theaters, or public transportation did not qualify as a bandage or incident of slavery. In a series of cases in the 1960s and the 70s, however, the court held that racial discrimination by private housing developers and private schools is among the bandages and incidents of slavery that Congress made under law under Section 2 of the 13th Amendment. Most recently, Congress has determined that Section 2 provides a basis for a portion of the Matthews Shepard, James Byrne Jr. Hate Crimes Prevention Act of 2009, which criminalized race-based hate crimes, and the Trafficking Victims Protection Act, which penalizes human trafficking and protects its survivors. The Supreme Court began to evaluate these laws. Despite its significance in American history, the 13th Amendment is not one of the most frequently invoked parts of our Constitution today. Not that slavery is a part of our past. The amendment's current relevance is subject to debate. That is, govern the fairness of modern labor practices. That is, empower Congress to pass broad-ranging civil rights laws. Whatever the outcome of these debates, though, the 13th Amendment deserves recognition as a historic and a solemn promise that slavery will never again exist in the United States. Manders debate. The first perspective, the 13th Amendment, a constitutional success story by Jennifer Mason McRoad. In 1865, ratification of the 13th Amendment was a transformative moment in American history. The first section of the Declaration that neither slavery nor involuntary servitude shall exist had the immediate and powerful effect of abolishing chattel slavery in the southern United States. Chattel slavery, let's see what that means. A personal possession. Okay. 1 year later, Congress used the power to enforce the ban on slavery conveyed by the second section of the 13th Amendment to pass the Civil Rights Act of 1866. Our nation's first civil rights law, the law invalidated the Blanco law passed by southern states after the Civil War that sought to keep the former slave effectively tethered to their former plantation owners. For example, when state law required all African Americans to enter into year-long employment contract and agree that it would forfeit the entire year's wages if they left before the year's end. The Civil Rights Act of 1866 ended such laws, convening, among other things, an equal right to enter into and enforce contract without respect to race. Although the Civil Rights Act of 1866 were controversial, Congress concluded that blank codes imposed de facto slavery, and therefore the Section 2 of the 13th Amendment empowered Congress to pass the act. Since those early days, however, the 13th Amendment has not been a frequently invoked part of a constitutional canon. Why is this? Most likely it is because the purpose of the amendment has already been fulfilled. Slavery is gone, and we have numerous laws in place to prevent and or to punish any form of coerced labor. Some argue that Section 1 of the 13th Amendment not only abolished slavery, but all of the racially discriminatory practices accomplished the institution of slavery. Thus, the argument goes, the amendment also banned discrimination and promises a full measure of freedom. The problem with this argument that is, in many ways, it renders the 14th or 15th Amendments redundant. The 14th Amendment makes all born within United States, including former slave citizens of the United States, and promises them both the privileges and the immunity of citizens and the equal protection of the laws. The 15th Amendment prohibits the denial of a right to vote based on citizen race, color, or previous condition of servitude. If the 13th Amendment itself is banning discrimination and mandated a full range of civil and political rights, there would have been no need for the 14th or 15th Amendment. Thus, it is quite understandable that the Supreme Court had to say that Section 1 of the 13th Amendment be best understood solely as a ban on coerced labor. The 13th Amendment paved the way for certain constitutional promises of equality, but did not itself provide for that equality. Section 2 of the 13th Amendment empowered Congress to enforce the ban on slavery, and you wanted to research it by appropriate legislation. According to the Supreme Court, federal laws passed pursuant to this provision can address a broad range of discriminated conduct that is coerced labor. To enforce the ban on slavery and involuntary servitude, Congress can address not only slavery but also its wages and incidents. Also, the Civil Rights Act for 1866 has been upheld as a proper Section 2 legislation. The Supreme Court struck down 1875 civil rights law, holding that race discrimination in privately operated business like hotels, theaters, and transportation was not banned or incentive for slavery. Since that time, Congress has legislated activity pursuing the Section 2 has been radically restrained, particularly with respect to conduct that is not close contact to coerced labor. Some scholars have argued that the Section 2 of the 13th Amendment provides Congress with untapped power to pass nationwide civil rights legislation. This argument states that Congress can label a broad range of discriminatory practices and statutes and incidents of slavery and then address them legislatively. However, Congress has not actively adopted this theory, and the increased number of judges, scholars are skeptical that is correct. They argue that the concept of the bandages incident of slavery has a limited range of meaning and thus constrains the topic on which Section 2 permits Congress to legislate. Moreover, they argue that Congress should legislate only which find that there is a close connection between current discrimination and present or future conditions of slavery or involuntary servitude. Likely would it be difficult for Congress to satisfy this inquiry. This argument about the scope of the Congress power under Section 2 of the 13th Amendment is starting to play out in challenges to the Matthew Shepard, James Byrd Jr. Hate Crime Prevention Act of 2009. that act, among other things, makes race-based hate crime punishable under federal law. While a racial-motivated violence was certainly part and partial of the American system of chattel slavery in the past, the questions of whether there's any historical connection is sufficient for Section 2 purposes, or whether there must also be a link today between racially motivated violence and present or future conditions of slavery or involuntary servitude. These questions may ultimately lead the Supreme Court to issue another of its aware opinions on the meaning of the 13th Amendment. Next perspective. The 13th Amendment as a constitutional imagination. Gemma Green. The 13th Amendment is easy to overlook. Section 1 of the amendment officially prohibited chattel slavery, but by the end of the Civil War, its return was already unthinkable. William Lloyd Garrison, the country's most famous abolitionist, helped rein the fighters in by attending the flag-raising ceremony in the Fort Sumter on the invitation of the Secretary of War. Amendment note, there was no going back. Secretary of War at that time was Stanton, I think. Okay. So Fort Sumter is the place where Civil War started. Okay, so the 13th Amendment prohibits indentured servitude and peonage, but does not extend to other forms of involuntary service such as military or jury duty or work by convicted prisoners. To the extent the amendment reaches official racial discrimination, it is overshadowed by the 14th and 15th Amendment, which seem to go even further. But the 13th Amendment is distinctive and its constitutional potential remains untapped. Most significantly, Section 2 of the amendment empowered Congress to enforce Section 1 by appropriate legislation. This language has never appeared in the constitutional amendment, but it echoed the famous words of McCulloch versus Maryland in 1819 decision, in which the Supreme Court referred to appropriate federal laws in order to signal a broad scope for congressional power. In an unbroken series of cases beginning in 1983, the Supreme Court has understood Section 2 to permit Congress to pass all laws necessary and proper for abolishing all batches incidents of slavery in the United States. It's beyond question that this language permits Congress to forbid certain private acts and not just acts of states. As in early exercise Section 2 power, Congress passed the Civil Rights Act of 1866, which the Supreme Court has construed as prohibiting racial discrimination in the making and enforcing contract in property transactions, even by private parties. More recently, Congress used this authority to prohibit racial-motivated violence. These laws are grounded in the view that slavery was not just the holding of black Americans to unpaid service, but an entire system of social relations designed to enforce a racial hierarchy. Refusing to enforce contract of blacks, barring them from leasing or owning property, and assaulting them with impunity were among other abuses, widespread in the states of the Confederacy before, during, and immediately after Civil War. This practice denies equal citizenship standards, implicitly the humanity of African Americans. The basis and instead of the racial hierarchy persisting in the United States, the 13th Amendment authorized Congress to address them. The 13th Amendment should permit Congress to redress further issues, including bidding practice that effectively exclude minority contractors from economic life, admission policies that exclude minority from selected colleges, universities, and electoral practice such as voter ID laws, and the prohibited voting windows that have the effect limiting minority practice participation. Significantly, though, the 13th Amendment singles out slavery and involuntary servitude, it does not single out race. Accordingly, Section 2 also empower Congress to reach social and economic relations that are akin to slavery and peonage. Marriage laws once abided and facilitated the economic and physical subordination of women and denial of women's individual personhood. Well, that may be an overreach. This amendment solely based on solve the problem of slavery, but maybe not every standards and provinces society today. Anyway, let's continue. The Supreme Court should not, therefore, have invited the Congress' attempt in the 1994 Violence Against Women Act to provide a federal remedy for women who are the victims of sexual and other forms of gender-based violence. The 13th Amendment provided ample authority to pass that law. And make another law, make another amendment. American workers are also protected by the 13th Amendment. Employers who coerce undocumented workers into accepting subsistence wages, who pressure employees not to follow worker compensation claims, and who rob them tips the overtime pay are in direct violation of the Constitution. Or to use that one law to reach every aspect, and every injustice in the society is unthinkable to the drafters' thoughts. Anyway, the Congress power under the 13th Amendment also sought to be broadly construed to permit it to require good faith collective bargaining, which federal labor laws already require, and to mandate that both public private employees pay union dues, which federal labor laws do not require, thereby permitting such bargaining to survive. The 13th Amendment has awoke before inspired the National Labor Relations Act and peonage laws, fair housing laws, sex trafficking laws, and hate crime legislation. Amendment's true potential is not so much to require judges to invalidate particular practices or even to empower Congress to legislate to protect civil rights. Rather, it is to motivate ordinary Americans to understand the persistence of a social caste, whether because of race, gender, or economic standard, a situation as a constitutional injury that should not exist in the United States.